Hello, thank you very much for coming, and a very warm welcome to those of you who have come here in person. It's very nice to see you. And those who are joining us online, I'm really sorry for those who are joining online and possibly to those who are here in person, but in case of an emergency, you won't be sorry, because I have to read out an announcement that if a fire bell rings, please walk down the main staircase the way you came, out the front door. The assembly point is across the road into Lincoln's Inn Fields. So that said, I am very excited and very honoured to chair this event, where we will be discussing some of the challenges to the woeful carbon emissions reductions targets around the world, environmental pollution, and the persecution of climate protesters. We hope to give you some insights on the key legislative, litigation, and policy tools that we can all use. And our speakers today have been right at the forefront of climate change litigation in domestic and regional courts, fighting for justice and shining a critical light on the climate crisis. Before I hand over to them, because what they have to say is much more important than what I have to say, just a few words about the context within which we are meeting here this evening. I mentioned 4 fairly disparate recent events which demonstrate the far reach of climate change in our society. First, a report that was published this week in Nature Sustainability, led by Exeter University, and warning that more than a fifth of people on Earth will live in extreme temperatures by the year 2100, with more than 1 billion forced to migrate if the planet continues on its current climate change trajectory. Second, the protests in Italy, which saw the Trevi fountain in Rome turned black. Italy, which, as we know, has seen a displacement of some 40,000 people this year due to extreme floods. Thirdly, and only today, the LSE Grantham Research Institute published a report on how the stock market reacts to news that a climate lawsuit has been filed or that a corporation has been found in breach. The hope is that lenders and regulators and governments will consider climate litigation when making investments and ultimately drive for a greener corporate behaviour. Fourth and lastly, we saw domestically that last week the formal introduction of the Climate and Ecology Bill to the House of Commons with full cross-party support. And we'll be hearing more about that later on. So with that context in mind, I trust that this event will inspire both hope and action. And to borrow the words of Greta Thunberg, hope is something that you have to earn. Real and transformative hope is, in my view, profoundly linked with action. And to achieve meaningful hope, we must roll up our sleeves and act. So, with those introductory words, and on cue, my colleague Marc Willers KC has his sleeves permanently rolled up, including this evening. I'm delighted to introduce Marc, who will be speaking to you together with Paul Clark, who doesn't have his sleeves rolled up, but does metaphorically. And they will be speaking to you about using international law and human rights in climate litigation, challenges and strategies. Over to you, Marc.
Thank you very much, Irena. And good afternoon, early evening to everybody who's attending in person. It's lovely to have you all here, but also to all those who are attending online. Sorry you can't be with us, but hoping that some of the things that are said by myself and my colleagues, my learned friends, are of interest to you. So I'm going to be talking in the main about a case that was heard very recently by the European Court of Human Rights, that being the case brought by the senior Swiss women against Switzerland, the first case to be heard, first climate change case to be heard before the European Court of Human Rights. back on the 29th of March, so very recent in my memory. And I'm also going to be touching on a couple of other cases if I have time, cases which have been decided in domestic courts and one or two that are in the pipeline. Can I just perhaps touch on some of the context? Thank you, Irena, for giving us an insight into why we're here and what we're talking about. But perhaps I can add some flesh to those bones. Back in 2019, the United Nations High Commissioner for Human Rights, Michelle Bachelet, said that climate change is a reality that now affects every region of the world. The world has never seen a threat to human rights of this scope. The economies of all nations, the institutional, political, social, and cultural fabric of every state, and the rights of all your people and future generations will be impacted. Now, the Intergovernmental Panel on Climate Change, the IPCC, has produced a number of reports over the years, and each one is more stark and demonstrates, what a collision course we're currently on in terms of the impacts that climate change will have on us, our societies, the most vulnerable people in our societies, and biodiversity. In 2021, the IPCC said that it's been clear for decades that the Earth's climate is changing and the role of human influence on the climate system is undisputed. And we know that human-induced climate change has adverse consequences for natural and human systems, in particular food and water security and human health, and that every fraction of a degree of warming increases the adverse effects of climate change. Now, in that context, back in 2016, a group of Swiss senior women, by that I'm talking about those of pensionable age, over 65, but many over 75, formed an association and brought a case before the Swiss domestic courts, arguing that the Swiss government had failed to tackle climate change, had failed to take the appropriate and necessary measures to protect the interests of its citizens, and particularly elderly women, who they claimed, and with the benefit of scientific and medical evidence, were disproportionately affected by the impacts of climate change, and particularly heat-induced impacts. Now, that case was rejected at every stage by the Swiss domestic courts, and ultimately, having been rejected by the Supreme Court in Switzerland, the senior Swiss women and their association lodged a complaint with the European Court of Human Rights, claiming that their rights had been breached by the failure to tackle climate change, those rights being their rights to life under Article 2, their rights to protection of their family life and their physical health under Article 8, and their rights under Article 6 and Article 13, given that the way that their case was rejected by the Swiss court meant that they had no effective remedy for the breaches which they alleged the Swiss government had inflicted upon them. Now, the case then made its way to the hearing, which took place on the 29th of March, much more quickly than one would normally expect, because the senior Swiss women's case and a couple of other cases, one of which Paul will be talking about, the Duarte Agostino case, and another case brought by a gentleman called Cherryl against France, were fast-tracked by the European Court of Human Rights. So they came before the court so much more quickly than is usually the case. And I've represented applicants who've had to wait many, many years before their case even got to the court for determination, let alone for that judgment then to be handed down. On the 29th of March, it's important to note that the court there was considering not just the merits, but also the question of whether or not the case could even be admitted. So the hearing was about admissibility and the merits. Before the case had got to court, a significant amount of written submissions had been made by both parties and indeed by interveners. And there were many NGOs, scientists, universities, and indeed other member states of the Council of Europe that made interventions arguing for or against the case put forward by these Swiss senior women. So by the time that the case got to the European Court of Human Rights, everybody was very much well aware of the arguments that both sides were putting. The court itself had clearly engaged with the issues and had sent to the parties a number of very, very searching and challenging questions, some of which it asked the parties to address during the course of the hearing. Now, the hearing itself was only scheduled to last about an hour or an hour and a half, would you believe? So when it comes to domestic proceedings, we're quite used to being able to talk for quite some time and often go beyond the time limit set by the judge, sometimes to the annoyance of the judge. In the European Court of Human Rights, we were given half an hour to put our case orally. The government was given half an hour. The interveners, and there were only two of them allowed to make submissions, were given about 15 minutes each. And then there was a tranche of questions posed to the parties. And the parties were sent out of the courtroom for 30 minutes on this occasion to answer those, or at least to consider what answers to give. By the time the hearing had finished, it was about 11:30 in the morning. And this is, the first ever climate change case. So, just a world away from the sort of experiences we have in sometimes even in magistrates' court, let alone in the High Court or the Court of Appeal or Supreme Court. Anyway, the court itself had asked the parties a number of questions, as I said, challenging questions, some of which were to be answered orally at the hearing within our 30 minutes that we were given. So really adding to the speed at which we had to deliver those submissions. On the morning of the hearing, something we couldn't really quite believe, on the morning of the hearing, we were invited in to see the president of the court, Judge O'Leary, just so that she could lay down the ground rules, as is normally the case in the European Court of Human Rights. As we walked into the judge's chamber, we were handed a tranche of documents, some of which were in German, which the Swiss government indicated they wanted to rely upon in answer to the questions that had been posed by the court, which the court had said would have to be addressed orally. So there we were, in the sort of situation that one might expect one to be in the magistrates' court or the Inner London Crown Court or somewhere like that, with shenanigans, this kind of nature being played out, presumably in order to ambush us. We couldn't ask for an adjournment. Everybody was there. The courtroom was crowded with hundreds of people who'd come from Switzerland. 21 judges were due to hear this case. It wasn't going to be a case for an adjournment. So we threw our hands up in the air and the judge said, look, you're not going to have to answer these submissions. You can get them translated. You can make submissions in writing in a couple of weeks' time. But it just kind of underpinned what we thought was something of an unprofessional approach taken by the Swiss government. Out of the judge's chamber, back into court, everybody waits for the bell. The judges are announced and in they walk, 21 judges, 5 of them substitute judges because there could be some time before the judgment is issued and some judges might have changed over and handed over their, as it were, their appointments to their replacements. Sitting down, the president announces the case, and at that point, the Swiss government get up and make their submissions. 30 minutes later, we get our chance. And I'll just take you through, if I can, the arguments were put by both parties. The Swiss government argued that the applicants were trying to circumvent the Paris Agreement by bringing this claim before the European Court of Human Rights. Now, the Paris Agreement is an international agreement which was laid down in 2015. 196 or 197 parties, state parties, have signed up to it. And what the Swiss government was saying is that by bringing this case before the European Court of Human Rights, the applicants, we were inviting the court to act as a kind of an international or a supreme environmental court. The policeman or woman or of the Paris Agreement was something which the Swiss government said should not be a role for the European Court of Human Rights. It was also argued that the unprecedented and complex issues and challenges of climate change, as well as Switzerland's democratic system, warranted it being given an ample margin of appreciation, a wide latitude when it came to making decisions as to how to tackle climate change and what targets for carbon emission reductions it should adopt. And those submissions were pretty much supported by the Republic of Ireland that had been chosen randomly, I assume, although the president is from the Republic of Ireland, but randomly as the most suitable state to make oral submissions by way of intervention. We made the following submissions. We made the first point, and I should say that it wasn't me speaking at this point. Jessica Seymour Casey from Matrix Chambers was also instructed and began our submissions and said at the outset, wearyism, defeatism, neither is an option. Every country, institution and policymaker must meet their responsibility to do all that is necessary to mitigate the impending harm. And then she began the submissions that we made, and we began by arguing that the failure of the Swiss courts to determine the applicant's case at all, on the grounds that there was, and to quote, still time before the Paris Agreement temperature thresholds were reached, and that accordingly the applicants could not yet claim that their rights were affected. That finding of the Swiss courts, we said, breached our clients' rights protected by Article 6 and 13 of the European Convention. We then addressed victim status, explaining the direct effects on the applicants of the Swiss government's ongoing failures to tackle climate change, relying on scientific data and papers to show that the applicants were already suffering from the effects of climate change, given that they, as elderly women, were subject to excessive and sustained high temperatures, and that those arising from increasing frequent and severe heat waves posed an extremely serious threat to their health and indeed put their lives at risk. And we pointed to some evidence which showed that there was a disproportionate number of deaths amongst elderly women during heat waves in Switzerland to, as it were, ram home that point. The Swiss government accepted that elderly women were disproportionately affected by excessive heat, but they nevertheless contended that the claim was nothing more than an actio popularis. Our case in response to that was, well, the association itself that had brought the claim, as well as a number of individuals, was really no more than a large group of individuals, each one of which were directly affected and could have brought the claim themselves. But rather than bring, say, 2,000 individual claims, we were bringing one through the association. The applicants also placed great reliance on the decision of the Dutch Supreme Court in the Agenda case, and a groundbreaking case where the Supreme Court of the Netherlands made the point that a state's positive obligation under Articles 2 and 8 apply to activities, whether public or private, which contribute to climate change on the basis that climate change is known to involve a real and immediate threat to life and also to citizens' well-being. We argued that the court should follow the lead of the Dutch Supreme Court and conclude that Switzerland was under a positive obligation to take the necessary steps to guarantee effective protection for the applicant's rights, health and well-being. We then addressed the failure on the part of Switzerland to take adequate steps to mitigate climate change and went through the scientific data, making it quite clear that they have not done enough. And we made the point that the court was not being asked to determine whether or not Switzerland was compliant with its obligations under the Paris Agreement, but rather whether or not Switzerland's failure to tackle climate change violated the applicant's rights under the convention. We said that they were two different things. The evidence that we relied upon was taken from climate analytics and a group of scientists who had, I think, also supported the Agostino case that Paul will be talking about, and the Climate Action Tracker, which is an independent scientific project that tracks government climate action and measures it against the globally agreed Paris Agreement target. And Climate Action Tracker is something that you can access online, and it identifies the extent to which governments across the world have actually complied with the Paris Agreement, and it goes into some detail in terms of each and every country's policies and targets. And so we were able to rely upon that and put that before the court. Switzerland had no real answer to the points that we raised, at least that's the way we read their response. They said that they'd taken some adaptation measures. Well, that's great, but there's an obligation not just to adapt to climate change, but also to mitigate its effects. And we were arguing about mitigation. But they also relied, as I said, on their ample margin of appreciation. And on the latter point, the margin of appreciation point, we accepted that they were entitled to a wide margin of appreciation. But the margin of appreciation related to the question of what steps the state should take, not whether they should take them at all. We made the point also that if the remaining global carbon budget is distributed fairly on the basis of the principles of international environmental law, such as common but differentiated responsibilities and respective capabilities, then Switzerland is already using other countries' shares of the small remaining carbon budget. And we described then what Switzerland was effectively doing as carbon theft. When it came to the general defences that the Swiss government put before the court, and they included those which are often trotted out in cases of this kind, such as, well, Switzerland's actions alone wouldn't prevent or avoid the risks that climate change poses, and its failures cannot therefore be considered causative of the relevant harm and risk. We again took the court back to the decision of the Dutch Supreme Court in the Agenda case, where it roundly rejected, I should say, that type of defence. We also made the point that, the drop in the ocean argument, which Switzerland would rely upon, has to be viewed in the context where every degree, indeed every fraction of a degree, the temperature increase matters. And another argument that Switzerland put forward was that they couldn't be held responsible for their failures to tackle climate change because of the fact that the Swiss population had rejected an earlier attempt to bring in new climate legislation. We countered that point by saying, well, it doesn't really matter what form of democracy one has. The European Court of Human Rights, and indeed the members of the European Court of Human Rights, the members of the Council of Europe, must do all that they can to protect their citizens' human rights, whatever the democratic system is in operation. And finally, we stressed the urgent need for Switzerland to make the necessary emissions reductions, noted that its actions to date have been woefully inadequate. There were no signs that it would change course, before arguing that it was essential that the court itself order Switzerland to take the necessary measures. We concluded the argument, the oral argument, with this submission. There is no time left. Dangerous climate change is with us. The applicants are suffering and fear the future. Switzerland has no excuse for its failures to protect the applicants' rights. It has known the harm that inadequate action would cause, and despite that knowledge, it has failed to act with sufficient urgency and application, undermining global effects and mutual trust. If a country as rich and technologically advanced as Switzerland cannot do its fair share, indeed does not even take the trouble to assess what its fair share should be, what hope is there that other countries will step up to face the challenge? That's where we ended it. As I said, there were questions, 11, I think, maybe 10 or 11 questions posed by the judges, more than we anticipated there might be. They were addressed briefly at the end of the hearing. And as I said, by 11:30, we'd finished. I got rung by a reporter at the BBC, and I said I'd take the call, and she said, "So what are you going to be arguing?" We've already done it. This is 11:30. It's like finished. And we had, after that, I should say, the most amazing after-court experience. The 100 or so senior Swiss women and their followers and many, many others attended an event at a venue nearby where we had the most marvellous kind of after-court celebration. And we weren't prejudging what the judges were going to say, far from it. There was music, there was dancing. You should have seen the barristers dancing in the wigs and gowns. We had poetry, we had a commemoration to those who had passed away. Those of the senior Swiss Women's Association who had died since the proceedings had been issued. It was the most amazing experience of, I think, my career, certainly after court career, and one I'll never forget. And, I need to say something about the clients because they were amazingly inspirational. Some of them I couldn't speak to personally because there were 3 or 4 different languages, and I'm not very good with my languages. We had Swiss, we had French, German, and Italian. So women from the various regions of Switzerland speaking different languages, but all there committed to this amazing case, which wouldn't have got anywhere without the brilliant Swiss legal team that kicked it all off and ran it through the Swiss courts, knocking their heads against brick walls at every stage, and then bringing the case before the European Court of Human Rights. And I was only just lucky enough to be brought in at the last minute, really, the last 6-9 months, to be a part of it. And I'm so grateful to all those that thought that was a good idea. Greenpeace also helped enormously in terms of supporting the case. And there are many people working with Greenpeace who did an amazing amount of work on the comms side, and also supporting the lawyers and ensuring that everything went smoothly. So, it has to be said that I played a very small part, but I was so happy to have played that part, and that others deserve a huge amount of credit for getting the case to the court. Now, what the decision will be is anybody's guess, but we like to think that we won the day in court, and it will only be, and it's quite a big caveat, but it'll only be the political nuances behind the scenes that might scupper our case on at least one of the grounds that we argued. So we're hopeful that we're going to get some. We're hopeful too that when it comes to other cases before the court, particularly the case that Paul is working on and is going to tell you more about, that we're all successful and that we can galvanise other, in our case, elderly women around Europe, possibly around the world, to bring similar cases before their domestic courts, and also ensure that vulnerable children and adults and senior women across the board are able to put pressure on their governments to step up to the plate and take all the action that they need to take. So, without further ado, I think I've been given the deadline.
I'm so sorry.
Time's up. And if anybody wants to talk about some of the other cases, I would perhaps want to talk about later, we can raise those in questions.
Thank you very much, Mark.
Can we just give a round of applause? That was just such an epic.
Over to Paul.
Thank you. So what I'm going to try to do in my 20 minutes, I hope it's 20 minutes, is two things. First of all, to examine or identify what some of the key barriers seem to be to climate justice as revealed by some of the domestic decisions, particularly in Europe. But the same issues reappear in the North American cases and some of the African cases as well, in terms of the ones that I'm going to refer to. And then second, to consider how international or transnational law, in particular as revealed by the submissions in the Duarte Agostinho against 33 states case, might begin to provide some way of fighting back. But before I get into that, I think it's first important to say what the barriers are not. And it's perhaps quite surprising to think about the extent of agreement between the applicants and the 33 state respondents in Duarte Agostinho. The applicants and the respondent states in the submissions agree that climate change is a severe threat to the global community, that it's an unprecedented challenge in its magnitude and scale, and that there's an imperative for urgent action to address that threat. The following are also not disputed: the global causes and impacts of climate change, the climate impacts in Portugal, which is where the applicants are, and the limits of Portugal's adaptive capacity, the imperative to keep global warming to the 1.5 degree limit, the trajectory as leading to a temperature increase of 2.6 to 2.8 degrees on current policies and commitments, the need for rapid global emissions reductions outlined as necessary by the IPCC, the need for steep declines in fossil fuel production, and the contribution to climate change of embedded and overseas emissions of entities domiciled within the respondent states. All of that agreed. Perhaps that's not surprising, because the states do not and could not question the undisputed science of the IPCC, the UN Environment Programme, and others. And that covers a great deal of the substantive ground. That tends to suggest that all of these states are acting unlawfully, doesn't it? Well, much of what is left are much more legalistic controversies, and it's those that I'm going to try to identify and then figure out how this case or international law might help in providing a solution. So what are the barriers? Well, let's have a look at some of the domestic cases. First of all, courts taking a preliminary approach of saying simply there's no standing. In the UK and before the Court of Justice of the EU, applicants have been unable to access remedies due to a lack of standing. And examples of that are some of the Plan B cases in this country and the People's Climate case, or Carvalho and others, in the Court of Justice of the EU. The applicants wouldn't have reasonable prospects of success in the respondent states where the domestic courts have assessed the merits of human rights-based climate cases and found, rather than saying there's no standing, perhaps even worse, that states don't owe duties under the Convention at all in relation to climate change, or have not breached those duties. Examples of those cases appear in Austria and in Norway, including in the excellent cases brought by Greenpeace. And then there's another category of cases, which are, and I'm going to pay a bit more attention to these, because these cases are formally successful. And there's quite a few of them, and perhaps the best known one is the Agenda case. So in these cases, respondents, there have been formally successful climate cases, but the available remedies wouldn't, we say, be capable of providing redress to the applicant's case. So in Agenda, for example, the Dutch Supreme Court found that Netherlands' pledge to reduce emissions by 17% by 2020 was a violation of Articles 2 and 8 of the ECHR. But the court examined the adequacy of the pledge against the lower limit of its share in the measures to be taken against dangerous climate change. In other words, it selected the lowest end of the fair share range as its appropriate benchmark. Now, that was, among other things, influenced by the principle of judicial restraint, which we hear all the time in judicial review. But the point is that I want to get across here: if all states pursue the least stringent end of their permissible fair share range, it's absolutely impossible to get anywhere near the 1.5 degree limit. Case of Neubauer and others in Germany. In that case, it's held that an emissions target aligned not with 1.5 but with 2 degrees was constitutional. It relied for that reason on the possibility of alleviation from adaptation measures. And in addition to that, that obvious fiction, given the state of the technology, etc. But they also, again, relied on the leeway afforded to the legislator to being taken into account. So because of the principle of judicial restraint, the German court couldn't find fault with the government's decision to base its 2030 target on an equal per capita approach to fair share of a global budget consistent with, in that line of analysis, 1.75 degrees. Now, it's important to emphasise that among the many different approaches to burden sharing, equal per capita is a self-serving measure for most developed states. And if all states adopted self-serving choices within permissible fair share ranges, again, we would get nowhere near the 1.5 limit. A number of cases before the French Conseil d'État, including perhaps most well known the case brought by Notre Affaire à tous. In that case, the Conseil d'État held that France had to adopt measures to achieve its 2030 target, but declined to review the adequacy of that target at all. And here, this is a member of a category of cases that we see throughout the world where the issues are entirely procedural. So it's entirely to do with whether or not the existing law is being complied with, whether enough information is being provided, etc. No substantive analysis of the adequacy of the targets. Similarly, Friends of the Irish Environment, the Irish Supreme Court, held that the island's mitigation plan breached national legislation by failing to specify how to achieve a transition to low-carbon, climate-resilient and an environmentally sustainable economy. It held that the Irish government's national mitigation plan should specify certain information required by relevant domestic climate change litigation, but beyond that narrow question of statutory construction, it did not assess the extent to which Ireland was required to reduce its emissions. I've got more examples, but I think I've made the point. The same thing can be said about the Klimatica case in the Czech Republic and the Climate Act case in Belgium. So, in each of the above cases, in each of the cases that I've described to you, the domestic courts have failed to effectively address what are really the key issues here. If the domestic courts in all states adopted these approaches in assessing the adequacy of emission reductions targets, the aggregation of those measures would be entirely inconsistent with achieving the 1.5 degree limit. And that's no criticism of the choice to pursue these cases, but what it does is I think it reveals key ideas which underpin the approach taken at the domestic level and the domestic courts. And I'm going to try to identify some of those now. So first, saying that choices about climate change and emissions reductions are in the political realm, not the legal realm. Similarly, reliance on concepts related to the separation of powers to disempower the courts and say that the big distributive choices are not for them. Strict views of causation. Gas obviously crosses borders. It's unsurprising that traditional models of causation are not going to provide any justice here. I've alluded to the lack of agreement globally on burden sharing, the lack of a clear standard to apply. And then in turn, the emphasis on national level decision making, and as a corollary, an effort to restrict responsibility to the limits of the state rather than seeing it as a global issue, as it should be. And then more generally, there's a dominance of political concepts over judicial or legal, and national concepts over global concepts. So all of this, what these ideas do, I want to suggest, is that they sustain what led Levin and others a long time ago to describe the climate change as a super wicked problem, which is, as they described, a label that arises from problems with 4 features. Time is running out. Those who cause the problem also seek to provide a solution. The central authority needed to address it is weak or non-existent, and partly as a result, policy responses discount the future irrationally. And it's these structural features of domestic litigation which seem to allow that state of affairs to continue. So, those are the difficulties. Now, how can transnational or international law begin to help with this? And what I'm going to try to do is, without going through all of the issues in Duarte Agostinho, to highlight a few to show how the approaches deployed in that case might be able to provide some way of pushing back, including in the domestic courts. So four areas. First of all, causation in the context of the argument about victim status. Second, the approach taken to the ambiguity of the standards in the context of arguments about whether or not a state has in fact breached its obligations. Third, the political versus the legal in the context of the margin of appreciation. And fourth, the limits of the state in the context of both the concept of jurisdiction and the approach taken to exhaustion of domestic remedies. Now, in the time left, I don't know whether I'll get through all that, but I'm going to give it a bash. So in the context of causation, the states, unsurprisingly perhaps, argued for an incredibly strict but-for approach to causation, the very same thing that we see in the domestic courts that has prevented some of the cases from succeeding. But it's a straightforward matter of ECHR law that that standard is not required. There's no need to establish an immediate causal link where future risks of harm are concerned. And in positive obligations cases, it has to be established that the state's failure to take reasonably available measures could have had a real prospect of altering the outcome or mitigating the harm. So there's a straightforward answer to that in the case law. The standard of causation that the respondent states sought to apply put the bar far too high. Without authority, they tried to add a gloss to the potential victim test set out in the Senator Lines against Austria case, asserting that the applicants had to establish a strong connection, their words, between the alleged interference and the victim's private sphere for the purposes of Article 8, and had to provide detailed evidence of the harm suffered. But this position is premised on a misunderstanding that there's a need for the applicants to establish but-for causation. And that goes well beyond the real prospect of mitigating harm test established since the case of O'Keefe, in which it was held explicitly that it wasn't necessary to show that but for the state, the interference would not have happened. So, arguing that the applicants had to prove the degree of probability of damage, which is another one of their submissions, goes far beyond the Senator Lyons case and is contrary to the principle that the applicants didn't need to establish quantifiable harm. It's sufficient as a matter of straightforward ECHR law that there's evidence from which inferences can be drawn that the applicants will inevitably be made more vulnerable to the interference with their rights. So to some extent, you've got assistance from the case law, but the additional element we hope in Duarte Agostinho is that, leaving aside the strict application of the black letter law, it's surely somewhat more compelling if we're saying that 33 states are together rather than just one. So there's an aesthetic element to that choice as well, in addition to the shared responsibility issues, which I'll come back to. So that was causation. Moving on to the actual substantive standard that we seek to apply, Marc's already made reference to the Climate Action Tracker. And when the Duarte Agostinho applicants, as against the respondents, when the respondents seek to demonstrate the adequacy of their mitigation measures, the applicants argue that they're required to do so according to relatively more demanding approaches to measuring their fair share, which is in effect is the methodology in the Climate Action Tracker. So where there's ambiguity surrounding what constitutes the state's fair share, for example, comparing historic emissions per capita, ideas about burden sharing, or its economic wherewithal, then that uncertainty has to be resolved in favour of the applicants. In effect, that means that states' mitigation efforts have to be assessed according to the relatively more demanding measures of their respective fair shares, consistent with the methodology of the Climate Action Tracker. I'm not going to go into the nuts and bolts of that, but the genius of it is that it offers a methodology which doesn't require persuading the court to choose a particular approach to burden sharing. And there's a greater emphasis placed on the extent to which those various different points in the fair share ranges are consistent with the highest possible ambition concept in the Paris Agreement. So what these types of arguments do is they aim to prevent the otherwise inevitable attempt of states to shift of responsibility away from themselves and onto other states for the impact of climate change. So that's the way that the ambiguity of the standard is attacked. Third thing, the margin of appreciation, and in particular this battle of the political versus the legal. Now, the respondents in Duarte Agostinho have relied, and those of us who practice inquests will hear this argument very frequently, that the systemic obligation under Article 2 is satisfied essentially by the existence of, and I'll put it colloquially, any old system. They say that there's a detailed legislative and administrative framework to tackle climate change. But of course, that does not demonstrate compliance with Articles 2, 3 and 8, where those frameworks don't provide the effective deterrence against threats posed by climate change that is required of the states by ECHR law. And nor does the existence of those frameworks, without more, mean that the states have complied with their duty to take reasonable steps to protect the applicant's rights from climate impacts. Another way that the respondents are putting their argument is by asserting that the only question for the court is whether there's been a manifest error of appreciation. I've heard Marc talk about the margin of appreciation here, but even those very words, the threshold of manifest error of appreciation, has only been referred to in 3 environmental judgments and a series of travellers' rights judgments handed down in 2001. It hasn't been endorsed in any recent case law or Grand Chamber authorities concerning the environment. Of more general interest, really, goodness, of more general interest perhaps is the fact that the state's defence rely on having an excessively wide margin of appreciation, without which they wouldn't have any prospect of establishing that they had taken reasonable and effective measures to protect against the threats posed by climate change. They make no attempt to properly engage with the arguments that the applicants have put forward, that there are a number of features which are apparent in the case law which narrow the appreciation, which is to do with the nature of the rights at issue, the gravity of climate impacts, the comparative weakness of states' competing interests, and the feasibility of compliance with the state's duties if they don't act together, and the quality of the state decision-making process. I'll just say this in terms of the margin. There's a critical difference between the issues in cases such as Hatton against the UK concerning the regulation of noise pollution and that of climate change. In Hatton, the margin of appreciation, which was recognised, was relied upon to determine the extent of the interference to the rights protected by Article 8, which was permissible in that case, having regard to the competing economic interests at stake. However, if in the case of climate change it's accepted that the ECHR has to be read in light of the temperature target prescribed by the Paris Agreement, then the interference to the Article 8 rights that will result from global warming exceeding that target can't ever possibly be viewed as necessary in a democratic society. So the question that the margin of appreciation was relied on to answer in Hatton is, in the context of climate change, already answered. It's just not on the table. The best available science is entirely clear, but to the extent there's any uncertainty in that regard, the precautionary principle, which the applicants also rely on, comes into play as regards the precise amount by which the atmosphere will warm on the basis of current emissions. The most likely projected temperature increase will cause devastating impacts to the applicants and others. But the uncertainty that the application is concerned with in Duarte Agostinho relates primarily to the fair share question. So I've already mentioned how there's uncertainty as to exactly how to share the obligations of states across the world. And on this issue, and ultimately on the determination of the amount by which emissions must be reduced, rightly understood, states shouldn't enjoy a wide margin of appreciation. And that follows from the very nature of the margin as a feature of the principle of subsidiarity. So in Handyside, the court noted the margin arises from the observation that by reason of their direct and continuous contact with the vital forces of their countries, state authorities are in principle in a better position than the international judge to give an opinion on certain matters relating to the interpretation and implementation of the convention. So clearly states' contact with the vital forces of their country is of limited relevance when it comes to determining the extent of their obligations to mitigate the global problem that is climate change. And conversely, the European Court is very well placed from its vantage point as an international court to determine whether a state's mitigation efforts are consistent with the temperature goal. So in all of that to say that in the area of climate change mitigation, in very much the same way as I think was argued in the Swiss case, the margin of appreciation is absolutely confined to the choice of means, nothing more. Now, given that I'm out of time, but Owen's kindly lent me a bit of his, I'm going to skip over jurisdiction and just talk a little bit about the perhaps obvious question of how the question of exhaustion of domestic remedies speaks to the relationship between the domestic and the international. So why was the Duarte Agostinho case filed directly with the European Court of Human Rights before the applicants exhaust domestic remedies? Well, the applicants first make the entirely reasonable argument that it wouldn't be practically feasible for them to pursue proceedings through the domestic courts of 33 state respondents. But they also argue that so far the domestic courts in Europe, and this returns to what I said at the beginning, have not provided adequate remedies in respect of inadequate climate mitigations. So this, together with the exceptionally urgent need for the provision of adequate remedies throughout Europe, further justifies their filing of an application directly with the European Court of Human Rights. The respondent states also, and this is a related point, trying to resist the notion that people should be able to file directly with a transnational court by reference to a floodgates type argument. But far from that being the reality of the situation, the guidance, and this is the key point to think about the relationship between the transnational court in Strasbourg and the domestic courts, the guidance that would be provided would assist domestic authorities and courts in ensuring effective remedies are available on the national level in future cases. Now, there's a number of ways in which you could see this happening, but one of the most obvious would be adoption within the context of the ECHR of the Climate Action Tracker methodology as legally enforceable in the context of Articles 2, 3 and 8. There are a number of other ways where that argument could be made, but that interplay would entirely undermine any notion of floodgates. Now, that argument is entirely consistent, we would say, with the principle of subsidiarity, which has always existed alongside well-established exceptions to the exhaustion of domestic remedies rule. It's also worth noting that the remedy that the applicants seek from the Strasbourg court is a declaration rather than an order requiring the states to reduce their emissions by specific amounts, as in Agenda. Crucially, the judgment that's sought from the European Court of Human Rights would encourage domestic courts to make Agenda-type orders, but at a level which ensure the collective consistency of Europe's contribution to the global mitigation effort. It would allow for much greater actual compliance with the limit in reality that the Paris Agreement sets out, which we would say is a perfect example of subsidiarity in action. I'm definitely over time, so I'm going to stop there.
Thank you very much, Marc and Paul. That was absolutely fascinating. And I'm so sorry to go strictly, albeit not very effectively, because we are over time. Can I suggest that we have a 10-minute break? There are refreshments at the back and facilities are just outside. Thank you very much. Right, thank you all. I am not going to say anything by way of introduction, and I'll hand over to my brilliant colleague Owen Greenhall, Garden Court Chambers, to kick us off in the second section on environmental protester rights. Over to you, Owen.
Thank you. So from the heady heights of Strasbourg and dancing with Swiss seniors and suing 33 states all at once, I will move to something much more domestic and give a brief update on injunctions and, most importantly, how to fight them. 2022 saw ever-growing injunctions covering ever-increasing swathes of this country. I guess the starting point was the National Highways Limited injunction that was as a response to the Insulate Britain protests. That covered the entire strategic road network. It was only prevented from going all the way from Land's End to John O'Groats by jurisdictional matters at the Scottish border, so it effectively went from Land's End to Berwick-on-Tweed. The other injunctions last year included HS2, which had an injunction all the way from London up to Chester. SO Pipeline got an injunction covering 100 plus miles in the south of England. Shell Oil has an injunction which covers all petrol stations in England and Wales which display a Shell branded logo. It's quite clear that a lot of those injunctions concern protests relating to environmental matters. And it's quite clear that those injunctions show the power of private companies to protect their interests, and injunctions have effectively become the tool of choice for large multinational companies seeking to restrain protests against them. So with all these injunctions in place, there was also consideration by the higher courts about whether it is in fact permissible to have a final injunction granted against persons unknown. Those are the types of injunctions which are the most powerful form of restraint. And the Court of Appeal in the beginning of 2022 held that a final injunction was possible against persons unknown, but it would have to be reviewed annually. That case has gone to the Supreme Court and was heard in February of this year, and we are awaiting judgment. So as things stand now, the Court of Appeal judgment is what is binding, and as stated, final injunctions can be granted, but they have to be subject to effectively an annual review. And given the timescales of when the injunctions were granted last year, they are now all coming up for review again. So it is sort of injunction season and these companies are heading off to court and seeking to renew their injunctions. Now, more importantly, how to challenge these kind of injunctions. There's two things that I want to talk about, two glimmers of light in the otherwise depressing picture that's presented. The first is how it relates to a little-known provision of the Civil Procedure Rule, CPR 40.9. And that is a means by which a person who is affected by an injunction, or by a court order generally, can make representations and seek to vary it without becoming a party to proceedings. The reason that's important is because previously the only way to challenge an injunction that's brought against persons unknown, so it binds anyone, would be to make yourself a named defendant, become a party to the litigation, become enmeshed in the ongoing civil claim, and, more importantly, put yourself at risk of costs. And the costs in these kind of cases shouldn't be underestimated at all. It's not unheard of for a single day's hearing in the High Court for the claimants to put in cost bills of over £100,000. There's no doubt that the cost consequences are very serious, very significant, and have a very significant chilling effect of anyone who might be interested in seeking to limit or challenge the granting of the injunction in any way. So CPR 40.9 is a way to put yourself forward without becoming a named defendant to the proceedings and to make representations, particularly at the return date of an injunction that's granted on a without notice basis or on an annual review hearing, and to say, well, look, this injunction either should be got rid of completely, it's not needed, it's disproportionate, or needs to be tweaked in this way, there's some important aspect of it that hasn't been considered. And it was in one of the early National Highways injunctions that Mr. Justice Nathan first used CPR 40.9 as a means to allow a non-defendant to make representations against the order. That was then picked up in the case of SO Petroleum when Mr. Justice Ritchie fleshed out the test to apply and whether the court should permit someone to make representations under CPR 40.9. And he effectively set out two threshold questions. The first is the person directly affected by the order? And he said that the court should take quite a flexible approach to that, quite a broad approach, not look at does the order actually prohibit someone from doing something that they're currently doing, but in general, might it have an impact on something they want to do? And that's particularly the case if fundamental rights, such as the right to protest, are engaged. And the second question is, does the potential party or non-party have a good point to raise? Are you saying something sensible? And then he set out a number of factors, 7 factors for the court to consider when making that assessment. And importantly, those factors include whether the civil rights of the applicant are affected, whether there is a wider civil liberties or public interest point raised more generally. So not something that specifically touches on the potential applicant. And also, is the order geographically or temporally large and widespread? And the court needed to have a closer scrutiny of those kinds of things. These are all factors which are very much germane to these kinds of cases, these environmental protest type injunctions. And all of that has very recently been approved in the case of Shell Oil, persons unknown review hearing, which was handed down yesterday. So, if anything, I can't accuse by not being up to date the latest case. So that's one chink of light. And the other topic I want to talk about is the test for granting an injunction. Now, these persons unknown injunctions are formally forms of interim relief, so they are not the final disposal of the claim. Those of us who went to law school not that long ago can probably remember that the test for interim relief is from the case of American cyanamide, and it's a relatively low threshold. It's really, is there a serious issue to be tried? And that's very much, it works in the favour of companies seeking injunctions, and it's not a high threshold for them to try to get the injunction off the ground. Section 12 of the Human Rights Act has a particular provision in relation to court orders which affect freedom of speech. And what Section 12.3 says is relief is not to be granted so as to restrain publication before trial unless the court is satisfied that the applicant is likely to establish that publication should not be allowed. So it's effectively puts the burden on the claimants to prove that they are likely to succeed in their claim at trial, rather than simply that they have a serious issue to be tried. Now, that was first applied in the Ineos injunction case, and it was really applied both in the High Court and the Court of Appeal in that case without too much analysis. It was kind of assumed that it applied. But more recently, there's been pushback against that, particularly at the High Court level. So in the Shell Oil case last year, Mr. Justice Johnson made an order prohibiting protests on Shell petrol stations, and he held that Section 12.3 didn't apply because restraining protest isn't restraining publication. That order was made without notice, so only the claimants were there at the hearing. In fact, someone did turn up to the hearing and asked to make representations. Mr. Justice Johnson refused to listen to them. It also is a strange conclusion for each, because one of the acts which his order prohibited was writing anything on anything in a Shell petrol station, and quite how that doesn't fall in the publication is hard to see. But it is worth looking at the case law, and you can see precisely what Section 12.3 doesn't apply to. And effectively, the case law says that what publication means in Section 12.3 is any act of communication that falls within the scope of Article 10 of the European Convention. So Article 10 protects freedom of expression. Something is expressive, whether something is expressive is effectively whether it has an expressive quality. That's an objective test. Not everything that falls within Article 10 is necessarily going to be an act of communication, but the vast majority of things will be, and particularly in the protest context. So Mr. Justice Johnson was correct when he held that Article 10 and the scope of publication for Section 12.3 weren't the same. But when you look at protests, almost anything is going to be an act of communication. That's going to include even something which doesn't have the explicit use of words. So a die-in protest, for example, could quite easily be seen as a form of communication. It's designed to communicate a message to an audience. And again, that argument was all approved by Mrs. Justice Hill in the Shell Oil case handed down yesterday. So she upheld that the test that ought to be applied in these cases is Section 12.3. Those are two tools which we now have that can be used to fight against the wide-ranging injunctions brought by multinational companies. And as for how things will turn out in the future, I guess all eyes are now on the Supreme Court, and we're all waiting to see what will be decided in the Wolverhampton case. And as to how that will go, who knows? But fingers crossed. That's it.
Thank you very much. Thank you very much, Owen. I'll hand over to Audrey, Cherryl, Mogan, again, private court chamber.
Thank you. So I'm a criminal defense practitioner. I'm going to try to speak in about 10 minutes about everything related to climate catastrophe protesters in the criminal courts. Given that seems like all I do right now, 10 minutes might be a little bit short, but I will try. Obviously, climate emergency protesters, the issues are ranging. Obviously, you've got the big organizations from big protest groups like Just Stop Oil and Extinction Rebellion. But the work that I've done in the criminal courts go all the way down to small things like the Great Crested Newt. I do like talking about that every time because it just shows you the wide-ranging scope of the impact of the climate emergency. But I do think I've given maybe some version of this talk for quite many years now, and I wish I could say it would be different, but it's quite depressing. That is the truth, what is happening to protesters generally, but climate catastrophe protesters in the criminal courts. And we know that because obviously the rhetoric from the government is such that we see its direct impact on the ground. I saw just the other day, there were JSO protesters doing a slow reverse walk, and there was an individual that just came and dragged people off of the street and tried to push them around. Shockingly, though, in that case, the police actually intervened and arrested the guy who was pushing them, which I think, that's the shock. But we saw that with Insulate Britain as well. Obviously gluing your hand to the ground is a well-known kind of protester tactic, but people were just coming and ripping people off of the ground and throwing them away, throwing them to the side so they could get through. And really, it's clear that this is coming down because of the language of the politics in relation to, and Tory politicians, but with really no kind of real opposition about protesters. Clamp down again on, I think Preeti Patel said, so-called eco-crusaders turned criminals. That kind of language is, of course, going to inflame those aggressions kind of on the street. So how is all of that kind of translating into the courts? Well, I'll say very similarly. When climate protesters find themselves in the criminal courts, what I think is a trend over the last, I'd say 5 or 6 years now, is you're getting more and more serious offenses being charged. I know when the first big XR protests were happening, lots of people were being arrested for obstruction of the highway, Section 14 offenses, not leaving, that kind of stuff. But now we see more and more people are being charged with conspiracy offenses, which are indictable only, so they go up to the Crown Court. Lots of public nuisance charges, as opposed to Insulate Britain. People were in the highway, but instead of being charged with obstructing a highway, they were charged with public nuisance. Public nuisance, I say a little bit about that. There's now, it was a common law offense, and most of the protesters so far we've dealt with have been charged under the common law offense. Now it has statutory footing. That will be for offenses that take place after the 28th of June 2022. And if anybody knows anything about the criminal courts, we're definitely not dealing with a lot of cases that, we're going back to 2020 at best. So right now, the public nuisance charges are the common law offences. And an interesting thing around that is that in the statutory offences, under the Section 78 of the Police Crime Sentencing Courts Act, the one that everybody tried to kill but didn't, that there is an actual defence under subsection 3 to prove that they had a reasonable excuse. And reasonable excuse, we would argue, has to consider people's Articles 10 and 11 rights to protest. The common law offence doesn't have that. And so those arguments are making their way through the court. Because the IB cases are still being heard, I think there was 67 defendants just in the London courts. Can't say much more about that, which is slightly anticlimactic. But that is kind of this public nuisance as something more serious, but also the interesting question about what happens when somebody is charged with an offence that doesn't have reasonable excuse built into it, and what that might mean for their right to protest. So these more serious offences, obviously the penalties are much more significant. So I've spoken about those in general, but I also have an HS2 protester charged with some very serious, it was Roald Dahl Woods, St. Jones Hill Woods, charged with some really serious, indictable only criminal damage with intent to endanger life, some really, big offences for effectively sitting in tree houses to stop the destruction of woods that inspired famous authors. It's really, really worrying to see that level of serious charges being leveled at people. Now, there are pros and cons to this. Obviously, the con is exactly what, I'm probably gonna get in trouble for saying this, but what politicians want, right? They want longer sentences. Protesters are being put into prison now after conviction, and there are more serious penalties. Obviously, other cons is it takes a really long time. Like I just said, my HS2 case dates back to 2020. There are some pros. We spoke a little bit, Marc mentioned about the magistrates' courts. My opinion, as far away as you can get from a magistrate court, more likely to get some form of justice. And just because I like telling the story, when the first XR cases were coming through the MAG's courts, I would be in court at City of London representing someone, and this was like hundreds and hundreds of cases coming in and out. I know from my solicitors that the dates were being changed consistently, like constantly. They were changing the dates of when somebody was to show up, and I'd be there for a first appearance. So the first hearing in this magistrate's court, just to set down what we're going to do, our defenses, set down a trial date, whatever. Unrepresented defendants, when they called their name, if they weren't there, the court would basically just say, fine, let's continue to trial, right there and then. The first time I heard that, I actually turned to the DJ and I said, and to the prosecutor, I was like, you guys must be joking, right? They're like, no, that's how they were dealing with it. Forget about even their right to be there, disclosure, anything. It was horrific to see what they were doing, knowing that I had come and I would say things that any counsel there would say, well, actually there was big mix-ups with dates. I tried to say, how can you do that when you know that there's the admin around this has been so poor? No, let's go ahead to trial. If they want to deal with it, there was that, I know it couldn't be that. I don't know what they were going to do with it, but that's the way. I mean, magistrates court is very much a factory farm of convictions, but this was something like I'd never seen it before. So more serious charges means that you're at least not dealing with that kind of a court. But again, protesters are going to prison now, and that is something that needs to be thought about. So I'm just going to quickly talk about some of the legal defenses we've been trying to run. There was a high point in the life of climate change protesters and protesters generally. It was the case of Ziegler. I feel weird about talking about it because that was basically Owen Greenhall's case. But I will talk about it anyway. You can correct me if I've got anything wrong, but it was definitely a high point in the last few years. effectively the court saying that there should be a certain degree of tolerance to disruption to ordinary life, including disruption to traffic caused by the exercise of the right to freedom of expression or freedom of peaceful assembly. Ziegler was an obstruction of the highway case, but obviously it was the Supreme Court that handed this down. I mean, what they're saying there, I think, and the amazing lawyers who took it did a good overview of all the Strasbourg and domestic case law. I don't think that should be something that needs to come down from the Supreme Court. It sounds like something that anybody knows anything about human rights should understand, but it did come down. And importantly, what Ziegler talked about was that each stage of the criminal process is an interference with your human rights. So that's from arrest to charged, prosecution, conviction, and sentence. And that meant that each stage, they required that proportionality assessment. Because of course, in some cases, it might be proportionate to arrest you, to get you out of the street, to whatever reason, but not proportionate to then continue to a trial and convict you, or what sentence you get. The question of proportionality should be considered. So that was a high point. Kind of feels like just doing what we should do, but and you know, in Ziegler it referenced, you know, the well-known principles in relation to how you deal with this proportionality exercise. But effectively, the last question about that balancing exercise is if there is this interference, but it pursues a legitimate aim. There's a lot of lawyers in the room, so I'm just trying to go quickly through them. But is the interference necessary in a democratic society to achieve that legitimate aim? And the question of what is necessary in a democratic society, and you're in the Crown Court, you have 12 randomly selected individuals of the public with their own unique experiences and different backgrounds. I can't imagine a better group of people to decide what is necessary in a democratic society, to do that balancing exercise, to listen to what a protester did and weigh that up against the issues that they're talking about. However, clearly, this country, these courts, people don't agree that you should leave that to a jury. And what we've seen is effectively cases coming after Ziegler, narrowing the applicability, so much so that I haven't had a single case where we even have to look at Ziegler anymore since the Colston case. Even though it's the Supreme Court, that is kind of where we are. The case of Katurian came out, that was about HS2 tunnels. That effectively, in that case, they tried to draw this distinction about cases where you have a lawful excuse, so, or a reasonable excuse, and those in which you don't have that, and where they effectively say the offense itself has the proportionality analysis kind of within it. So if you can make out the offense, then it was per se proportionate. Well, it also tried to speak about this issue about Ziegler being specific to things like obstruction of the highway, which is a summary only offense, which means it doesn't relate to juries. That can't be right because, in fact, in Ziegler, the Supreme Court very much mentions juries, but you can see that this is an attempt to kind of close down on this amazing case that was helping us in the criminal courts. Then, of course, it was the AG reference case, which is the Colston statute case, not climate related. But in that case, you know, it kind of pulled back a bit on the Katurian point about freestanding consideration of Article 10 and 11. But what happened, and what happens in a lot of climate catastrophe protests these days, is some paint being applied to something. It's a long-standing protest tactic. But now the question really has, because of the Colston statute case, has come down to this question that if it's private property, then, well, is paint damage, throwing paint on buildings, is that damage? That has still been, so far, been allowed to be left to a jury. But the question of whether or not you can protest in that way, effectively, if you're on private property, unless it's something trivial, then you can't, and haven't so far had anybody say to us some paint on a building is trivial. Still fingers crossed, waiting for it, but that hasn't happened. And when it's public property, the consideration is whether the damage is significant, but the court making clear that the division of £5,000 between the Mags Court criminal damage and Crown Court criminal damage, this level of significance is much lower than it would take you to get to the Crown Court, i.e. your juries aren't going to get to hear the right to protest. That's how I take it. And then, of course, in the new Public Order Act, another protest tactic, lock-ons. That's now a criminal offence. In fact, of course, people have been arrested for locking on in under other kinds of offences like obstruction or aggravated trespass. But I've had a lot of cases where, say, a number of individuals break things or paint a lot of stuff and do what the Crown would say is significant damage, and other people have just been locked on, that there's an argument about whether or not it's actually proportionate to be charging them as well. So before there was this separate offence, there's these arguments about putting all of these people together when all these people were locking on the right to protest. Now, obviously, it's an offence by itself. Whether or not we'll be able to kind of get around that, we'll have to wait and see. So that's what's happened to the right to protest and Ziegler. But we don't only try to run Articles 10 and 11. There are other defences which have even worse luck. Things like prevention of crime, protection of property, necessity, which is basically acting reasonably to prevent serious injury or death, something that's imminent. I mean, our house is on fire, as everybody's saying. What more imminent can you really have? I'm Canadian. The wildfires across Alberta right now, it's northern Alberta. It's the worst that Canada's ever seen, that Alberta's ever seen. And the fires are so bad. I mean, I don't know how much you know about Canadian geography. It's the second largest country in the world, so it's big. But the fires are so bad in northern Alberta that they've come down to Calgary, and the air quality in Calgary is just so bad right now. People are, being evacuated. People were being evacuated from the north to come down to Calgary. Now there's a question about whether people can even stay in Calgary. So, and that's in the global north. That's in Canada, and that's what's happening. I think it's, this question of imminence, I can't even understand how it is a question. But all of those defenses, and this is going back to my jury point, have a question of what is reasonable in those circumstances. I'm not going to get into each of them. We can talk about them later if you want. But each has a requirement to consider the reasonableness of someone's actions in those circumstances. And again, my point is, how is it not the job of 12 randomly selected individuals to decide what is reasonable in those circumstances? They are literally the epitome of the reasonable man. Law students, Clapham omnibus, that kind of stuff. How can it be them, not them, but a judiciary that we have known through all the reports about the lack of diversity in the judiciary, whether it's gender, whether it's race, socioeconomic backgrounds. I just find that incredibly worrying and concerning about, well, I've probably said too much anyways, but I find it concerning that these questions that on the face of them should very much be left to juries are being decided by people in courts, obviously, through the legal system, but concerningly in courts where we know that there is a lack of diversity. And I would say usurping the roles of juries on what is the biggest issue facing life on Earth. Now, that is the chilling effect. Now, just before I end, I just wanted to think about one other question, and this is not so much about the courts, but just kind of taking a step back and probably leading into some of what Paul's going to speak about in terms of climate catastrophe activism. From my experience, I guess I question why there aren't more Black and brown climate catastrophe activists in the larger climate movement. So things like JSO, XR, in Slate Britain. Every time I've had a Black or brown client, one of the things they do say to me is, I'm doing this because I don't see a lot of people from my ethnic group there doing this. But clearly, and we've saw that in BLM movements and nobody's suggesting otherwise, it's not that Black and brown people don't want to come out to protest. So what is it, when we reflect, is happening? And just about my HS2 Jones Hill Wood defendant, just briefly, he was the only Black protester in a group of about 10 other protesters in the trees. And he was the only one charged with indictable offenses. Even on the evidence that was served to us about his case, there were so many other people doing things that were much worse than what he was accused of doing. And he was taken to the floor, beaten by the police, then charged with obstructing their arrest, and then a number of indictable offenses. After my favorite thing in the world, which is to harass with applications after applications, all of the offenses, save for one, have been dropped. But the kind of over-policing of Black and brown communities looking at that in line with, obviously, a lot of climate catastrophe tactics these days have been to be arrested, and that kind of conflict between the two and what that means, I guess is just something I thought would be interesting to reflect on with your drinks. And just, there are obviously organizations that are amazing, and I just want to read this little quote from Wretched of the Earth, which is a group of kind of various background individuals who are coming to together to campaign about climate emergency. But they wrote this letter to XR, and in it they said this: another truth is that for many, the bleakness is not something of the future. For those of us who are Indigenous, working class, Black, brown, queer, trans, or disabled, the experience of structural violence became part of our birthright. Our houses have been on fire for a very long time. So it's just something about considering how to center those voices that have always, I guess, had a very close relationship with nature. And just to end, and I am ending, to end on a good note with just because everything is so depressing in the criminal courts in relation to protest generally, but definitely climate protest. It's just a case we did recently in Wood Green, Beyond Politics. It was a bunch of protesters charged with various conspiracies to cause criminal damage. Effectively, they just went around political parties, including the Tory party, but Labour, Green Party, and spraying paint on them and smashing some windows. Also went to charities and did it, including Greenpeace. All the defenses were ruled out, so they weren't allowed to rely on Articles 10 and 11 or necessity, prevention of crime, protection of property that I talked about. There was this question about the conspiracy put together, but there was also a question of, and the question that always still gets put to juries, is that damage? Is breaking a glass window, smashing a glass window damage? That question was left to them. But also this question of consent. Yes, would the Tory party consent to their windows being damaged if they really understood about the climate catastrophe? Power to Greenpeace for coming and saying that they would consent. So that was nice. Not all parties were equally keen. But basically, despite all of that difficulty with not being allowed to rely on your right to protest and those defenses, all of the defendants that were charged with a conspiracy to commit criminal damage were acquitted unanimously. I've heard that the defendants have been calling it the miracle of Wood Green. I agree. And it does show you what a jury of 12 can do, maybe when they know about their right to acquit on conscience. But also maybe that's exactly what the courts are afraid of. Yeah, thank you.
Audrey. Paul, over to you. So I'm going to speak about activism, and both activism of climate activists within the legal system in the courts, and also activism by lawyers, and why I believe lawyers should give serious consideration to being climate activists in this time. So first, to climate activists in the courts. I think it's important to bear in mind what climate activists are seeking to achieve through the legal system. Some are, of course, seeking to be not convicted. but many are actually seeking to use the court experience as another part of their activism. Because these people aren't getting arrested on the road for no reason. They're not doing these protests for no reason. They're doing these protests to raise the alarm and shake our society out of its slumber that it has fallen into. And many of them see the court process and activism within that as a crucial part of that whole experience, and a crucial way to bring publicity to the climate crisis and to wake people up. So that's, I think, something important to bear in mind. As a result of that, many of them are representing themselves. And despite, we've heard how many defences are being ruled out, despite that, many climate activists have been being acquitted by juries when they've been able to put the seriousness of the climate crisis, including many. I think that the one with the winning streak is Reverend Sue Parfitt, who's a 78-year-old Church of England vicar, who has, I think, the most jury acquittals, to the extent that many people want her on their protest now as almost a talisman, because juries do not like to, it turns out, convict 78-year-old Church of England vicars who have taken such a deep, conscious stand about an issue, and the juries can really see that. However, of course, the English legal system never sits still and has reacted back against these acquittals. And the most obvious way that's been done is in the court of Judge Reed in the London Crown Court, where he has made rulings, which I don't think we're allowed to tell the detail of, but effectively not allowing people to put forward defences in relation to necessity, but even going further than that and not allowing people to mention climate change, the climate catastrophe, or their reason for carrying out protest in his court. And that has led to a form of civil resistance where various activists decided that they would, on their conscience, not allow the courts to do that to them, and nonetheless raise these issues in court and have been sentenced to prison for that. So a number of activists have now been sentenced to, I think, around 8 weeks, roughly, each, just for mentioning the climate catastrophe in an English court. And that in itself shows the ludicrousness of our legal system and where it stands on the climate crisis, and is in itself a form of valuable civil resistance. Moving on from that, because jurors are not allowed to be told in court about their right to acquit if they perceive the climate crisis as being so serious that it outweighs the actions that have been done by the defendant. Activists have begun holding signs outside courts. There's a very well-known case of Trudy Warner, who stood outside in a London Crown Court with a sign saying jurors have an absolute right to acquit on their conscience, which is effectively just a facsimile almost of a marble plaque that sits in the Old Bailey saying the exact same thing. Judge Reed got her arrested and has referred her to the Attorney General either for contempt of court or potentially perverting the course of justice. Now, what is interesting there is that obviously that is going to be fought in a legal sense, but activists have also fought it in an activist political sense and have been seemingly successful in that. In what I think is one of the most interesting I Am Spartacus actions that I've seen of the last few years, where 24 people went outside in a London Crown Court with the exact same sign as the jury were going in, as a direct challenge to Judge Reed to either say, you were wrong to arrest Trudy Warner effectively because you're not arresting us, or you're going to magnify this even more by arresting 24 people and creating a whole new story, which also gets the climate crisis and the English court's failure to grapple properly with that crisis into the media. He didn't arrest. I think that is in itself very interesting as an example of ways that these kind of rulings can be challenged both in the courts, but also in the streets, because they are inherently political. So I want to turn now to lawyers as climate activists, and why I believe that more lawyers should step up as climate activists, peacefully and lawfully. I should say that this is a reasonably controversial topic, so I predicate my coming remarks with these are my personal views and are not the views of Garden Court Chambers, or considered to be the views of chambers in general, because it is a controversial topic, and I have to recognise that. But I do believe that lawyers have a great power, more than almost any other profession, and with a fact sometimes 10 or 20 times what ordinary non-lawyers can do in their activism, because of the unique standing that our profession has. not only do we have a power, I believe we have a deep moral responsibility to exercise that power. You've already heard in the other talks the gravity of the climate crisis. I'm not going to reiterate that. But we are held up to be an intelligent and well-educated profession. We understand what the scientists are telling us. I believe we have no excuse for not acting on this. And no one can say they don't know or fully understand the gravity of the crisis that we face. And there are obviously amazing lawyers at Garden Court and at other chambers who are doing that through climate litigation, through representing defendants, doing a really amazing job day in, day out, which needs to be congratulated. But for those lawyers that don't have that ability to do that, we also have a great power. And for me, I realised I needed to step up into greater activism last year when I saw the Just Stop Oil protest. I think the one that really got to me was the young man called Louis who tied himself to that goalpost, which I think was an extraordinary act of bravery to go against that many people and that amount of in that social context, a level of bravery that I couldn't really comprehend. And also seeing a number of particularly older Just Stop Oil activists being arrested made me realise that I needed to step up. So I began doing just solo protest outside the Inns of Courts, just saying the bar must act on the climate crisis. That then led to getting involved with a few other lawyers thinking similar thoughts. There was a letter signed saying we must not breach 1.5, which I think is an example of something which, while useful, is not actually doing the level of radicalness that it needs to. And then Roger Hallam told everyone who signed that letter that if they didn't get arrested, then they're all complicit in genocide, which was maybe going slightly further than we needed to at that stage. However, out of that, and it was very useful because it actually made people think, okay, I can't get arrested. Actually, what I'm doing at the moment isn't enough. Because frankly, the gravity of the climate crisis means we probably should all probably be arrested. But if we can't because we're lawyers, then what can we do that is peaceful and lawful? And the answer is a lot. So with a group of the lawyers, I founded this group called Lawyers Are Responsible, and we worked up a declaration, which effectively was a form of civil resistance within the legal profession, where we said we wouldn't act to prosecute climate protesters, partially for the reasons around the Judge Reed stuff that I spoke about earlier, and we wouldn't act in new fossil fuel expansion projects. And we chose that very deliberately because to do so is, I believe, participating in an act of great evil. We know that any new fossil fuel projects from, I think, 2021, the IEA said, are not compatible with the Paris 1.5, and we know what the consequences of the breach of 1.5 is. Therefore, as night follows day, lawyers who undertake and assist with new fossil fuel projects are directly causing the deaths of tens of millions of people, at a minimum, probably hundreds, in the global south. It's as simple as that. And I have challenged and I will challenge any lawyer to tell me why that logic doesn't work and to challenge me in debate as to why helping new fossil fuel projects does not lead to the deaths of tens of millions of people in the global south. And that is why I call the huge amount of money that those lawyers sitting in offices just a few miles away from us, it is blood money. It is money being deliberately and knowingly earned at the sacrifice of lives of people in the global south. And that is why I refuse to do that work and why I challenge other lawyers to do the same. And that declaration had a real impact, far outside what we expected it would. Not all of it positive coverage, but as they say, all news is good news, even if it's the Daily Mail front page headline saying woke fury at woke barristers refusing to prosecute climate protesters. But has really brought this conversation about, and I know I'm running out of time, so I'll just summarize as quickly as possible. Other really interesting developments happened off the back of that. There is a group called Law Students for Climate Accountability in the US, and Lawyers Are Responsible, particularly with a number of other lawyers, requested them to do a similar report in the UK because we really need the stats, and law students are really well placed to do that research. And I think about a fortnight ago, they came up with an incredible report. If you haven't read it, Google Law Students for Climate Accountability, read it, get angry, and take action on it. It says, amongst other things, that since the Paris Agreement, so since we know we need to stop fossil fuel expansion, just English lawyers have facilitated 1.6 trillion of new fossil fuel work. And it lists them in order of what they've done it. And we're talking for Magic Circle firms, this is tens of billions of pounds of fossil fuel transaction work each. They are not doing this work because it's the right thing to do. They're doing this work because it is monetarily in their interests. And I believe that as lawyers, we have a huge role to play in making it not in their monetary interests anymore by peaceful and lawful action, which we are well placed to do, to call out these firms. And I believe one of their Achilles heels is in talent. We need to choke off the talent flow of young people whose lives these firms are destroying from joining their firms. And that is, I think, the soft underbelly of these firms. If enough young people refuse to join them and tell them why they're not joining them, then I believe that can have a huge impact. And as lawyers, we are well placed to start that, because I think with the best will in the world, if these law firms see it, Just Stop All Protesters, they can blank them. Oh, they're just a stupid hippie. But if someone's in a suit and they're also a lawyer and they're telling you that logically, using reason and basic facts that I outlined that equation to you earlier, what you are doing is immoral and you need to stop, I think that can start having an impact. And already lawyers are organising small demos outside these law offices to actually hand over letters to these lawyers to tell them to stop doing this work. I'm also looking into doing more of those. So if you're interested, that's something that I think is really worth doing. There's lots of them. They're all in the report. And even just going by yourself and just talking to people could make a real impact. Other final thing is about the issue of how we as a profession approach this. So for instance, at the bar, there's a debate ongoing between these two approaches, which the difference between net zero in the profession and lawyered emissions. You might be able to guess what that is, but net zero in the profession, which is the majority view at the moment, is that by putting some solar panels on our roof and printing on both sides of the paper, we are doing our climate obligations. As you might guess, I say actually it's about lawyered emissions. It's about the work that we are doing, the work that we are facilitating through, the new fossil fuel projects that we are facilitating through our work, which probably, no one's even done the research, and the Bar Council refused to do the research when I asked them. So we don't even know, but I'm putting a figure of between a factor of 100 to 1 to 1,000 to 1 on the emissions that we as a profession produce through our transport and electricity versus what we are causing via our lawyered emissions. And that is a debate that's ongoing, and I'd love other people to join the fray because I'm at the moment seen as a bit of an outlier, but I believe we need to really persuade both professions to act on that. The solicitors are doing better. The Law Society has put out a report again, which you should read, basically saying that solicitors can turn down cases if they breach climate obligations. The Bar is further behind, and I will, I think, be protesting the Bar sustainability event in June, which is taking a pure net zero in the profession approach, not mentioning lawyer emissions at all, and is being held at Herbert Smith. You know what they were, but I flicked into the Law Students for Climate Accountability report. Turns out they're the fifth worst firm, tens of billions of pounds of fossil fuel transaction work, and being addressed by the chair of the Bar, who himself is soaked in fossil fuel money. So I'm going to be protesting that peacefully, lawfully, completely within my professional obligations. The Bar Standards Board said that by signing a declaration we did nothing wrong, so there's no professional risk from it. And I do urge everyone to really think deeply about what your moral obligations as a lawyer are in this time, and to know that there is so much to do, and that I really urge you to join us in that work of doing it. Thank you.
Thank you very much. Last but not least, we have Oliver Sidorczuk, who joins us online, and he is the co-director of 0 Hour, who will be speaking to us about legislative and policy campaigning.
Great. Can you hear me, everyone? I can't hear myself, so I'll just dive in. It feels like it's getting towards people wanting a break and a refreshment, so I'll keep it short and sweet. My name's Oliver. I'm the co-director of 0 Hour, as has been said, and we're running the campaign for something called the Climate and Ecology Bill, which is a new proposal for a UK framework law to tackle the intertwined climate and ecological crisis. We were very grateful for the advice from Paul, Tim and Abigail from Chambers back in 2021. And I just thought it was worth referencing, that idea from Audrey of the utter bleakness of today is exactly why we're doing this. This isn't about something to protect necessarily the unborn. It's about people, current and future generations, of course, who are being impacted by the climate and ecological emergency now. And dare I say it, but if perhaps our MPs and government enacted the Climate and Ecology Bill or something equally strong and joined up, then it may go some way towards addressing the immense feeling across the world and the UK nations that we have to go further and faster in tackling the climate nature emergency. We've heard a lot about, obviously, litigation and case law, but legislation is we think, obviously fundamental to the crises that we face. And it's our mission at 0 Hour to lock the targets that we need into domestic law to make real those pledges that the government sign up to and don't seem to do too much more with at international summits like COP15, of course, the Paris Agreement, but most recently COP26. And the CE bill, just turn to that now, is a science-led and viable plan for new UK legislation that roots in citizens' voices at the heart of a new climate and nature strategy. And that is aligned with itself the latest science on what is required to keep 1.5 alive, as we keep hearing, but also importantly to halt and reverse the destruction and degradation, loss of nature by 2030. And that target is something that is all too missing from the recent Environment Act and wasn't in fact picked up in the Environment Improvement Plan. Very quickly, 0 Hour, we're a small environmental campaign going from 2020, and we've got the support of 168 MPs and peers from all parties for this private members bill that we are fighting to keep high on the government's and Parliament's agenda. We're supported by allies, including Garden Court, Lawyers for Nature, Bates Wells, but also the Wildlife Trust, Co-op Bank, Greenpeace, and anyone that's interested in joining our campaign. We really strongly encourage you to do that, as we're a largely grassroots campaign that requires and is built on the importance of people lobbying their local MPs and councillors to support this initiative. This is something that's worked before. The Big Ask campaign of 2005-2008 led to the Climate Change Act 2008, obviously with the then Labour Party's support. But the key that we're asking for is a joined up plan. We have a very disparate, siloed ecosystem, if you like, of laws in this UK that don't join up the dots. The bill that we're calling for was reintroduced in the Commons on the 10th of May with the support of all major parties. And I won't go into tremendous amount of detail because it's getting late and the details are on our website. But if it's made law, if it's enacted, the Climate and Ecology Bill would ensure that the UK nations working together and with the input of members of the public creates a joined up plan, given the climate and nature crises being deeply intertwined. This requires a plan that considers both climate and ecology together. On climate, it would cut emissions in line with 1.5 degrees, reducing them rapidly for the best chance of the UK limiting warming to 1.5. On nature, as I've said, it's not only to halt, but to reverse the decline in nature, setting nature measurably on the path to recovery by 2030. And this differs from the UK government's plans about species abundance. We're looking at nature in a much more holistic way in terms of ecosystems, species, and habitats. Fourthly, it's about taking responsibility for our overseas footprint, emissions, and ecological. As part of this, it's really important to prioritise nature in decision-making and end fossil fuel production and imports as rapidly as we can. But it also has a social lock, a fairness lock, to ensure that no one and no community is left behind. And it involves the public. This is something that a lot of people are clamouring for. We're proposing a climate and nature assembly to bring public opinion along to really facilitate the unprecedented pace of change that's required, because of course a lot of this reform that we want to see involves individuals and communities' ways of life. So just to dig into that a little bit more, specifically the bill would require the Secretary of State to deliver a strategy based on the following fundamental principles. On climate, it's about limiting the UK's total CO2 emissions to no more than its proportionate share of the IPCC's remaining global carbon budget, for a 67% chance of limiting global heating to 1.5. Now, that's obviously a lot less pithy than net zero by 2050, but we don't think that that is good enough, and it clearly isn't good enough. But it's also important to reduce the emissions that are caused in the manufacture of the goods that we import. So we're proposing tracking those down in line with UK territorial emissions. Really importantly, I think we're also proposing reducing the UK's emissions of methane and other greenhouse gases, again at a rate consistent with limiting warming to 1.5. On fossil fuels, it's about ending the exploration, extraction, export and import as rapidly as possible. And in terms of ecosystems, we're talking about mitigating emissions. Sorry, let me just rethink that. To minimize the damage rather to ecosystems in that mitigation, as well as food and water availability and to human health as far as possible. And it's important to restore and expand those ecosystems to enhance the management and protect and enhance biodiversity. That's something around the mitigation and conservation hierarchy, which is a framework that prioritizes the protection of nature. I think that's super important. And finally, about the UK's entire ecological footprint, which is all often not something that's discussed in Westminster. We don't think about the ecological footprint nearly enough as we do with carbon. So we're trying to rectify that. Why are we doing this? As we've heard, you know, the UK's got a pretty poor track record. I know there's a lot of talk about it being brilliant in terms of its comparison to other nations. We have the 2050 target, but we don't account for international aviation and shipping until 2033. And current targets ignore almost 40% of the UK's emissions by not accounting for our imported emissions. So we're trying to lift the lid on what is something that is often brushed aside, that the UK's footprint is massive and does need to account for these other criteria. Turning a little bit now to what might sound obvious, but is something that we have to explain quite a lot to politicians and organisations, is that the UK's current strategy is heavily focused on this mid-century target of 2050. But of course, it's the cumulative emissions that matter, not the milestone date or dates. That's of course because global heating is proportional to cumulative emissions, and we're not taking enough action to reduce emissions now, perhaps gambling on speculative technology to deliver big cuts tomorrow. But we think if people do understand the concept of working towards a budget, that's one of the key benefits of switching over to a system of linking the UK's targets to the share that we've heard a lot about tonight of the remaining budget. This would match much more closely to the principle of how carbon dioxide actually works in the atmosphere. It accumulates, and so we do need to build an understanding that every tonne matters. Just turning now to our nature target, it's something that was promised at COP15. We're currently running a campaign called United for Nature. And if anyone's interested in looking at this issue through the importance of reversing the destruction of nature, please do visit our website where we have a petition that we're handing in to Number 10 on the 5th of June. It's something that we're trying to rapidly boost the numbers for, but we're not one of the huge environmental organizations, so any help there is much appreciated. And I'll just end it there because I realize that you all might want to drink, but this is about fairness and involving the public. We don't often hear in policymaking circles about the importance of how these types of huge changes need to be thought about from the viewpoint of a community or a worker or a union. So we are trying very hard to build consensus that this needs to be something that involves people. That's why we have this proposed citizens' assembly. That's why we're thinking about this as a UK-wide issue. It's not something that can be worked on alone. It does need to be viewed through that prism of obviously climate, health, nature, but also people. So I'll end it there. I'm sorry I couldn't be with you, but happy to answer any questions now or via email or anytime. So thanks for having me.
Thank you very much, Oliver. I'm sorry you can't be with us too, and enjoy a drink that I think we've all deserved. Before I close, can I ask if anyone has any burning questions of our brilliant and expert panel? If not, given how out of time we are, I am just going to thank everybody, you, the audience, for coming, and the speakers for all their inspiring and informative talks. Before I do that, there is a question, please.
Hi, I just wanted to say, I'm in Just Up Oil, and I've been on the road today, and it's quite terrifying. I want to say thank you to everybody who's come, because, and I'm going to be very quick because I'm going to get emotional.
No,
but it was amazing to be a member of the public and hear what people in the judicial system are doing, and like everybody's information and what you're doing, and I'm very grateful.
Well, I feel very humbled personally hearing that, and I also thank you very much for coming and the support that we've been bringing in whatever way, whether it's on an expert or a human level, is here for you. So, is there anyone else who wants to ask a question in public? You're obviously very welcome to ask any questions over a drink. In that case, again, thank you so much, and please stay, please enjoy yourself.